Past experience does not imply consent. This was held by a sessions court while rejecting the anticipatory bail of journalist Varun Hiremath, and which was celebrated by news across the country, saying it's a celebrated decision, saying that past consent does not imply past consent does not imply consent in the present scenario. Well, in a very anticlimactic way, the Delhi High Court single bench of Justice Mukta Gupta very recently, just around an hour back, granted anticipatory, at least interim anticipatory bail to the journalist accused person who applied under section 438 of the Criminal Procedure Code for anticipatory bail. Now, this particular scenario, according to me, holds a lot of significance because the Sessions Court, I believe, incorrectly carved out the jurisprudence. And in fact, I must say, this jurisprudence always existed, but carved out another angle to it, which is that even if there is proof of past sexual intercourse between the two parties, and even after delay in reporting the incident, can the court say that the applicant accused person should not be granted the admittedly discretionary relief of anticipatory bail or not? Because we do have a lot of cases where the perpetrator should go behind bars for no other reason but the severity of the offense, and also even during pending investigation, the possibility of influencing the witness, threatening the witness, or tampering with the evidence. However, in such a case where there is past consent, there is past sexual intercourse which has taken place between the parties, and then there is delay as well, in such a situation, can the provisions of the Evidence Act be invoked to hold what I would deem perhaps a summary trial, and for the judge to say the moment there is an allegation, we must believe the victim? I respectfully disagree. I respectfully say that a certain purpose must be served with the custody of the accused person. And certain news reports also talk about the lady's version. Now, I believe that these news reports state the version of the lady as given to the journalists themselves, giving in very detailed description the horrors that she faced. Frankly, from my experience in dealing with these kind of matters, it seems like a complete farce. The way that the whole situation has been painted out by the complainant. Now, of course, some of you may say, you are too quick to judge the complainant, you don't know her truth. I don't. But we don't know the truth of the applicant accused person either. At the end of it all boils down to this. This is not a trial, neither by the court, neither by the media. This is the application for anticipatory bail by an accused person. Bail, not jail, is a fundamental rule, a fundamental tenet of criminal jurisprudence, which is mentioned by the courts of law, the Supreme Court, all the high courts, time and again. Let us not lose sight of the fact that if a man is falsely accused, and if there is the smallest possibility that he is falsely accused in a case where there is past sexual experience between the applicant and the complainant, it will lead to a certain amount of reasonable possibility that there is false implication. Having said that, this is interim protection. We will yet await the final outcome. And as I always say, even if the High Court dismisses it, the accused person does have the option of going to the Supreme Court under a special leave petition. And even if the anticipatory bail is given finally as well, and the protection is made absolute, in a situation like this one where I see the Delhi police being very eager to effect an arrest, in all probability, even if anticipatory bail is made absolute, the police themselves, the state themselves, the NCT of New Delhi will approach the Supreme Court against the order granting anticipatory bail to the accused person. There's a lot still to happen. I don't really like reporting on events, yet, this is a topic which, having dealt with a lot of rape cases myself, something that I hope that justice will prevail, that common sense will prevail, and such an overbearing amount of onus may not be placed at the time of bail hearing upon an accused person.